If you've been charged with a DUI in Georgia, here are 4 essential strategies to help get your case dismissed or reduced. Number 1, if you have a breath test in your case, not a handheld portable breath test, but one on the Intoxilyzer 9000, there is going to be a key strategy in getting those breath test results thrown out. It is referred to as the 20-minute observation rule. Every breath test, according to the breath test operator training manual, must be preceded by a 20-minute observation period to make sure that breath test administrator is observing the person prior to the breath test, to make sure that person is not putting any foreign objects in their mouth or belching, regurgitating, or vomiting, causing alcohol to travel from the stomach up through the esophagus into the oral cavity. If that occurs, it's known as the problem of residual mouth alcohol and can falsely skew breath test results. So what the administrator does is this 20-minute observation. Frequently, the police never do it. How do we know they don't do it? Well, we can time on video when a person walks into the police station to submit to the breath test versus when they actually take the breath test. Almost always, there's no 20-minute observation. Plus, we can use the officer's dispatch reports, CAD records, CAD, to figure out when it is an officer is saying certain things over the radio that can be helpful in determining whether that 20-minute observation occurred. Number 2, challenging those standardized field sobriety tests. And the key word in making these challenges is standardized. These tests have to be instructed, administered, and interpreted by the officer the same way every time so that officer can say that they are getting consistent, reliable results. If an officer deviates or strays away from those standardized procedures, it can compromise the usefulness of the tests. So what do? We take a look at the video and we compare what it is that the officer is supposed to be doing according to their training manual with what they actually did on video, and pointing those things out to the prosecutor can significantly help the odds of resolving the case to no DUI. Number 3, challenging unlawful detentions by the police. Quite often, the police are unsure of how to proceed in a DUI investigation. It could occur as early as the initial stop. Did the police have sufficient evidence to justify pulling you over to begin with? If not, it can lead to the suppression of everything gained thereafter. If the police do have a valid reason to pull you over, what evidence do they have to then transform that initial stop into a new DUI investigation? A lot of times the officers can't articulate a specific reason, and we have gotten plenty of cases worked out to no DUI, either dismissed or reduced because of this continued detention issue. And then finally, once the police are interacting with you, are they giving you signals or formulating the investigation in a certain way that could create what's called a custodial situation, or the functional equivalent of arrest? If they do those things and you as a reasonable person would not feel free to terminate the encounter, in order for any of your later statements in response to police questionings to be admissible, they first must have read those Miranda warnings to you. And finally, number 4, using expert witnesses. Our office uses experts to help win these cases. First, we have an investigator, ex-Georgia State Patrol, who helps us assess cases. He gives us detailed reports of what it is the police did correctly and what they did incorrectly. This valuable insight helps us tremendously in presenting these cases to prosecutors, to judges, to juries. Also, we have an expert that we use, Dr. Spurgeon Cole. His area of expertise is in testing and measurements. He could tell us whether any type of scientific test passes scientific muster, whether it's valid scientifically. He analyzed the initial 1977 scientific study that went into supporting and validating these standardized field sobriety tests. He replicated that test, and his results were extremely similar to the initial study. The initial study showed that 47% of sober participants were wrongfully arrested. Dr. Cole's study, almost the same result. 46% of sober participants wrongfully arrested. Dr. Cole is extremely valuable to us as a law firm, and he's come in handy many times at trial and is showing juries why these tests are not scientifically valid, they're not designed to predict impairment, and they do a poor job of doing so.